have to worry about like this. But yet, you bring a whole bill that has questions whether it is even constitutional, that has questions whether it meets the court's approval of what we're trying to do with concealed carry. Folks, the process is really messed up. Quit. This is not the bill that everybody's debated, the bill that everyone has talked on, the bill that everybody wants to see out here. It is a ploy, and once again, your side of the aisle keeps trying to make ploys instead of dealing with the real issue. Keep playing games. Keep playing games. There is a time limit online. Do you know that one of the associations actually has a click down of when we have constitutional carry in the state of Illinois? And you want to endanger your citizens and keep playing games like this? Vote no.
The chair recognizes Representative Costello.
Thank you, Mr. Speaker. Will the sponsor yield?
She indicates she will.
Ladies and gentlemen, I don't know if anybody read Capitol Facts this morning, but something that was extremely important in there. If you look at the state of New York that has a May issue, 1/10 of 1% of their population gets a permit. Is that true, or do you know, Representative?
I have not looked into how many people get it in New York. I stopped reading at Rabid Gun Grabber.
Okay, well, when I look at it and I look at what is a constitutional amendment, constitutionally you have the right to bear arms. What if we had a situation when we're talking about the 15th Amendment, another constitutional amendment, if 1/10 of 1% of people were allowed to vote? We're talking about the Second Amendment, the right to bear arms, and we're talking about in many situations in the state of New York, you get people who are athletes, you get people who are politicians, who are afforded this opportunity, and the regular people of the state are not afforded this opportunity. We don't need bureaucrats issuing these permits to their friends and people as such, in my personal opinion, Representative.
This model has been upheld by 4 appellate courts, and this specifically addresses folks who can establish a need for personal self-defense.
And I go to the fact that it's 1/10 of 1% again. That's troubling. That's extremely troubling to me. This bill is too vague. There are many, many things, in my opinion, intentionally left out of this bill. Talking about the fee, do we want to make your Second Amendment rights a socioeconomic situation? We want to have a situation to where you could charge $1,000, $5,000, $10,000 for this permit.
Representative, the language in the bill very clearly states the fees are limited to the administrative and enforcement costs, which are going to vary by the geography of the county in question. And so they cannot be set in any other way. But they are limited to established costs for administering and enforcing the law.
Do we have an estimate of roughly what those costs may be?
I'm going to go back to that 6-month period. We have to work that out.
So the answer is no.
No. And it will vary by county.
I believe this is a very, very vague bill. The one thing that gets lost in these discussions at times, again, ladies and gentlemen, in my opinion, we're talking about your constitutional right to bear arms. I urge a no vote.
The chair recognizes Majority Leader Curry.
Thank you, Speaker. Members of the House, I rise in strong support of the amendment. This discussion about shall and may strikes me as something of a grammatical quagmire. Under the NRA-approved bill, you can't issue a concealed carry permit to somebody who's under the age of 21, who doesn't have a FOID card, someone who has a prior conviction for a felony, a violent crime, a drug crime, a crime involving the unlawful use or delivery of a firearm. There is no shall carry in the bill approved by the NRA. There is discretion in other states that have concealed carry laws, and today the New York law, the California law are all upheld by the court system as constitutional. In the Seventh Circuit opinion, that said that our law should be struck down, our law that allows no opportunity for public carrying of guns. The court said that it was legitimate for us to impose a balancing act to set the rights of people to be safe from guns that are out of control against the rights of people to be able to protect themselves. I think Amendment 1 to House Bill 831 does exactly that. It says no to guns, concealed guns, in places where there are large numbers of people, bars, theaters, arenas. It says that people should be safe in those territories. And it says that law enforcement should be able to make a determination whether there is a good reason for someone to have a concealed carry permit. If you want Illinois to be the Wild West, I invite you to vote against Amendment 1 to House Bill 831. But if you care about the safety and the health of your people, the safety and health of your people, not to be victims of violence out of control, the only responsible vote is yes.
The chair recognizes Representative Christian Mitchell.
Thank you, Mr. Speaker. Will the sponsor yield?
She indicates she will.
Representative Cassidy, is there precedent for May issue in case law?
There is. There have been 4 appellate court rulings upholding May issue.
Thank you, Representative. To the amendment, we are acting in this discussion as if somehow there has been a one-sided decision by the courts that binds us to do this only in the way that folks who are supportive of shall issue want it to be done. But let's be clear. In the Second Circuit in New York, they justified heightened regulation of firearms outside the home because public safety interests often outweigh individual interests in self-defense. There have been multiple cases where we have noted that the core value of the Second Amendment right is not necessarily something that allows us to ignore public safety interests. That there needs to be a proper balance between assuring access to handguns for those in need while preventing a proliferation of handguns in public that increase the risk to public safety. This is in case law. And let's be clear, nobody is saying that we're trying to take away guns from those who would like to have them. There's a different need downstate. There's a different need south of I-80. There's a different need in rural areas than there is in the city of Chicago. And respecting regional balance, respecting local control, as so many people want to do in every other aspect except this one, is extremely important because the city of Chicago and other urban areas have very different needs than downstate. We have a serious gun violence problem, and we need to make sure that we have the tools locally to address it as local law enforcement and local communities know how. I urge an aye vote on this amendment.
The chair recognizes Representative Drury.
Thank you, Mr. Speaker. To the amendment.
To the amendment.
You know, there's been a lot of talk in this room about the Constitution and what's constitutional, but the last time I looked around, there's not one single constitutional scholar sitting in this chamber. So why don't we stop with all the nonsense and talking about what's constitutional and what's not constitutional and get to what's actually in the bill and about what our Supreme Court, the actual scholars, have said. And it was just in the last week that the New York law was up in front of the Supreme Court of the United States, and the Supreme Court of the United States had the chance to take the NRA's appeal of the Second Circuit's opinion upholding May issue. And you know what the Supreme Court did? The Supreme Court decided not to hear the case because they were fine with the Second Circuit's opinion upholding May issue. That is the only opinion we have on the books from constitutional scholars. The Supreme Court declined to hear the case. So all of this nonsense, and it's absolute nonsense and two-facedness from the other side of the aisle, and I don't say this lightly, it's nonsense. It's nonsense, sir. It's nonsense. It is absolute nonsense. You know, you can scream all you want.
The House will be in order.
But
the House will be in order. The House will be in order. Representative Bost, you're not recognized. You are not recognized. Well, And you will not disrespect the chair either. Well, can you please? You do not have the floor. You do not have the floor. And Representative Drury does have the floor. I would not allow that if someone was doing it to you, and I would not allow you doing it to him. Representative Drury.
Thank you. So here's my point, members. We don't want someone like that carrying a concealed weapon.
The House will be in order. The House will be in order. The House will be in order. The next thing that I will say is I will call the doorkeepers. The House will be in order. The House will be in order. Representative Drury, I would wish that you would give your testimony, but give it in such a way that you are respectful to everyone in this House.
I appreciate that.
Please proceed.
The Supreme Court of the United States took this issue up last week. They declined to hear the Seventh Circuit's opinion upholding May issue. That is the law of our land, as it is right now. This is a good bill. It is a bill that is fair for everybody around this state. It is a bill that will keep us safe. It is a bill that deserves our aye vote. Thank you.
The chair recognizes Representative Sesha.
Thank you, Mr. Speaker. To the bill.
Bill.
Ladies
Amendment.
and gentlemen, I'm sorry. Ladies and gentlemen, this amendment is initiative of the Illinois Council Against Handgun Violence. I get that. It's opposed by the National Rifle Association. This entire debate over guns, as tragic as the issue was in Boston on Monday, it verified that guns don't kill people, crazy people kill people. It's what happened in Oklahoma City with fertilizer and fuel oil. It's what happened on 9/11 with box cutters and airplanes. Ladies and gentlemen, it's time we understood that guns don't kill people. And if Chicago has a problem with handgun violence, then Chicago should handle it.
The chair recognizes Representative Revelletti.
Mr. Speaker, I appreciate what you're trying to do, keeping this chamber in order. This is obviously a very emotional issue.
That Representative Revelletti, I really respect that, but then there is an issue of decorum on frankly both sides of the aisle.
And I understand that, Mr. Speaker. And what happens in these emotional debates is when we wait to the last second to try to pass these things, and then it becomes personal, unnecessary in this chamber, that anybody who just talked about who's constitutional scholars and who should decide who should carry firearms has just elevated themselves to chief in charge around this place. Those comments have no place in this chamber. If you don't like the legislation, don't vote for it. If you love it, put your name on it and speak for it. I don't understand what qualifies somebody to be a constitutional scholar or not, but I have a law license, Representative. I know how to look and brief a case and try to interpret what the court said so I can make the correct decision for my constituents, as well as something that complies with the United States Constitution and the Illinois State Constitution. And to a previous speaker about regional differences, let me opine about constitutionality and something called equal protection of law. There might be regional differences, but no citizen in this state should be treated any differently when it comes to protecting themselves if they're in Cairo or Carbondale or Chicago or Carpentersville. But some on the other side would say that's how it should be. There are regional differences, and we need to respect that when it comes to this. In this particular issue, it's about the Constitution, and we should all respect that. This is a retread bill. And it's not the Wild West, as another previous speaker said. If you go to the north to Wisconsin, it's the Wild North. And people are going to travel there for summer vacation. They're not going to be, oh, I won't go up there anymore because I'm afraid they have concealed carry. We'll go to the east to Indiana. They have concealed carry. I just visited relatives there over the weekend. I took my 11-year-old. I didn't say, oh, my God, they have concealed carry. I can't go over there because only Illinois is safe. Or to the west in Iowa and Missouri, or to Kentucky in the south. But we're right back where we were 6 weeks ago. It's time to pass something that comports with what the Seventh Circuit said. And I am entitled to what my opinion of that is. I don't need a lecture from somebody else to tell me what I think something is constitutional or not. I'm not a constitutional scholar, but I've spent 15 years with a law license in this state, which gives me some opportunity to discuss it with some semblance of professionalism and understanding of what the ruling means. I don't know why we had to go personal and tell somebody because they're passionate about an issue, they shouldn't carry a firearm. And to the people in the city of Chicago, those murder rates continue to go up. And the people of the city of Chicago are still not allowed to carry a firearm. And now they can go beg Sheriff Dart for a permit. And 60 days later, 90 days later, 120 days later, they'll be denied. And what's going to happen? Where will the outcry be when one of those people that applied for a permit is killed? What will happen then? We'll go to the Illinois State Police and say, you guys made a mistake? I have a great deal of respect for the sponsor, and I appreciate what she's trying to do, but this does not comport with the constitutionality. This should be debated on the merits of this amendment, up or down. It should not be made personal by anybody on this floor. There's no room for that garbage here.
Representative Cassidy to close on the amendment.
Thank you, Mr. Speaker. To the previous speaker, I share that respect, and I enjoy working with you, finding solutions, and you and I have been able to find common ground on a great many things that we began very far apart on, and I'm hopeful that on this issue we can work on that too. And I agree that we need to stay out of the personal. To the question of us being the last ones, I remember very clearly my mother saying it, and now as a mother I say it. If everyone else jumped off a cliff, would you have to do it too? We can do this in a way that works for us. We can do this in a way that has been upheld by the Supreme Court. We can do this in a way that recognizes that in my community, whether I have a gun or not is not going to stop the bullet coming through my window. It's not going to stop the bullet that hits a kid sitting on the porch. More guns are not the answer to the city's gun violence problem. To the question of double may that was raised earlier, both local law enforcement and state law enforcement have access to different information. It is important that all the information be utilized to determine the issuance of these licenses. The FOID records are not currently up to date. The delay is in there in order to make sure that all the appropriate information is available. When someone makes an application, we need to evaluate that application with accurate information in a timely fashion. This is an amendment that recognizes who we are as a state, what our communities are like, and acknowledges the deadline that we are operating under. It is far from the last minute. It is timely, it is fair, it is appropriate. I urge and I vote.
Representative Cassidy moves do adopt floor amendment number 1 to House Bill 831. There's been a request for a record vote on this amendment. So members, vote your own switches. All those in favor of amendment number 1, vote aye. All those opposed, vote nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Please vote your switches. To Patty. Rita. Mr. Clerk, take the record. On this record, with 31 voting yea, 76 voting nay, 6 voting present, floor amendment number 1 to House Bill 831 is hereby declared lost. Representative Boss, for what reason do you rise?
For a point of personal privilege.
Your point.
First off, apology to you, Mr. Speaker, as a person, and to you as a chair.
Apology accepted. Representative Boss, we're good friends, as you know.
And, Mr. Speaker, we've always worked well together. But let me also follow up by saying there is never a time that by the use of our First Amendment rights, we should be not denied our Second Amendment rights.
Thank you. House Bill 1773. House Bill 1773, Representative Sesha. Mr. Clerk, read the bill.
House Bill 1773, a bill for not considering civil law, third reading this House bill.
Representative Sesha.
Thank you, Mr. Speaker. Ladies and gentlemen, unlike much of the legislation today, this is basically a simple technical amendment wherein there is a common interest community association that, could I have some order, Mr. Speaker? If there is a common interest community association, it cannot enter into a contract with a member of that association. That's all this does, and I welcome any questions.
And the chair recognizes Representative Franks.
Thank you, Mr. Speaker. Will the sponsor yield?
Indicates he will.
I'm looking at the analysis, Mr. Sesha, and my understanding is you can't enter into a contract with a current board member if that board member or his or her immediate family member has a 25% or more interest.
You know, interestingly, Representative Franks, our analysis on my side of the aisle is incorrect. The analysis is. But it's any amount, 25% notwithstanding. But on my side of the analysis, it says a member of an association with a member of the association. It's supposed to say let me read it. The Common Interest Community Association cannot have a contract with a member of that association. That's all this does. It changes 3 words in the bill.
I'm looking at the bill itself. That's line 9 as I pulled it up.
Yes, sir.
And it says it took out a member of the board.
That's correct, sir.
But it would still allow, then, family members, correct?
I guess the best way I can answer that, Representative Franks, is Representative Neckritz, the chairperson of the committee, worked with us on this, and she's very knowledgeable of this type of law. And she was in complete agreement of our amendment number 3. And when you ask the question if it could involve a family member, I can't deny that. Perhaps it could. But I know that the association cannot have a contract with a member of that association.
And amendment number 3 became the bill, as I recall.
That's correct, sir.
Okay. But this is still a gaping loophole. Why would we say that a member can't have a contract, but the spouse of the member could?
Representative Franks, I guess the only thing I can do is what you would want me to do, is pull it out of the record, as much as I hate to, because we went through a lot of negotiations with Representative Neckritz. If she's in the chamber, maybe she'd be willing to comment on it, and I don't see her.
I don't know, Jim, and this is the first time seeing it, but as I'm reading it, I know that you're a good government type, and I don't think that you would, on purpose, leave a loophole.
I certainly wouldn't.
So if you leave it in, I'm going to vote against it and encourage people to, because I don't think the bill does probably what you want it to do the way it's drafted. I would ask you to take it out of the record if you'd like to work on it with the Representative Neckritz.
Representative Franks, whenever you've asked me to take anything out of the record, I've done it. we've really worked hard on this. We went through 3 amendments. The first 2 amendments, Representative Neckritz wouldn't even allow us to call because she said they literally did not meet the criteria that she felt was required. I believe now we're to a point where we have a good piece of legislation. I understand where you're coming from. I truly do. But I am going to ask the bill to move.
Okay. Well, it's into the bill, and I appreciate it, and I know your intentions are good. I just don't like the way the bill's written, and maybe, I don't know, maybe the representative can answer this, but the way it's written now, I don't think it's in our best public policy to allow these type of contracts to be had by spouses and family members of board members. So I would encourage a no vote.
There being no further debate, Representative Seisha to close.
I appreciate that, Representative Franks. I truly do. And Representative Neckritz is now in the chamber. If she feels she can impart anything to this that makes it clearer, I would welcome that. If not, I would ask for your aye vote.
Seeing no further debate, the question is, shall House Bill 1773 pass? All those in favor vote by saying aye. All those opposed, nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Zaleski, Williams, Rice. Marcus Evans. Mr. Clerk, take the record. On this question, with 116 voting yea, 1 voting nay, none voting present, and this bill having received the constitutional majority, is hereby declared passed. Representative Drury, for what reason do you rise?
Point of personal privilege, Mr. Speaker.
Your point.
Mr. Speaker, I'd like to apologize to the chair and to the members of this House to the extent that my remarks were taken as being a personal attack. It wasn't the intent. This certainly was a very heated issue, and we speak passionately. I think the sponsor had a good bill, but certainly don't want that to get in the way of the important work that we have to do. I have the utmost respect for this chamber and just want everybody to know that.
Thank you, Representative. Next bill for your consideration is House Bill 374. House Bill 374, Representative Martino. Mr. Clerk, read the bill.
House Bill 374, bill for not concerning finance, third reading this House bill.
The record. House Bill 1571. Representative Lane. Mr. Clerk, read the bill.
House Bill 1571, a bill for not concerning regulation, third reading this House bill.
Leader Lane.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, this bill simply allows insurance companies to purchase bonds issued by foreign countries. There's provisions in here from the Department of Insurance so that we make sure that they're qualified bonds under various circumstances. I know of no opposition to this bill, and I would ask your support.
The chair recognizes Representative Will Davis.
Thank you, Mr. Speaker. The sponsor yield.
He indicates he will.
Representative, in your description, you said that this would allow insurance companies to purchase bonds from foreign countries, correct?
That's correct, sir.
Is there any provisions in there that would prevent them from buying bonds from countries like North Korea? Any of those countries that we are having challenges with?
As far as we can tell, the only 2 countries that would qualify the way the bill is written is Israel and Canada.
Fair enough. Thank you very much.
There being no further debate, Representative Lang to close.
Please vote aye.
The question is, shall House Bill 1571 pass? All those in favor vote aye. Opposed vote nay. The voting is open. Have all voted a wish? Have all voted a wish? Have all voted a wish? Vote your switches. Hammond, Eunice. Mr. Clerk, take the record. On this question, with 118 voting yea, 0 voting nay, 0 voting present, this bill having received the constitutional majority is hereby declared passed. House Bill 827, House Bill 827, Representative Moylan. Mr. Clerk, read the bill.
House Bill 827, a bill for enacting criminal law, third reading of this House bill.
Representative Moylan.
Yes, sir. Thank you, Mr. Leader. This amendment, this bill states that it's the witness statement issue that a victim has the right to have the witness statement issued into the record. And I ask for an aye vote. This was agreed upon by the state's attorneys, Illinois Attorney General's Office, and the Cook County State's Attorney.
The chair recognizes Representative Rebelletti.
Will the sponsor yield?
He indicates he will.
Representative Moylan, I asked you some questions about this bill in judiciary, and I'm trying to figure out why this is necessary. Because it was under our impression that the victim has a right to have family members issue their statements before sentencing. The victims already have a right to issue statements. It's already codified. So what is this changing? What is this doing differently? Well, this makes sure that the prosecutor notifies the victim that they have the right to have people that were impacted, the family members that were impacted by the crime, issue statements how the crime affected them in a pre-sentencing issue. Does this apply to misdemeanors and felonies? Because there's not pre-sentence reports usually in misdemeanors. No, it's under my impression that's violent crimes. There are violent crimes under misdemeanor cases such as criminal sexual abuse, domestic battery, aggravated assault. Does this apply to that? I'm not sure, but when we were in committee, that wasn't brought up, Mr. Representative. And you say this, it's the state's attorney's obligation to inform the victim. When is that notice supposed to be given? As soon as the case is filed?